you, sir. On the third reading, I rise to reflect on the bill that we are dealing with. Through the course of this debate, I've listened to the second reading speeches. I'm yet to ascertain from anyone on the government side as to why they are pursuing this matter. Allegedly, the Chief Justice has made some comments that have been reported in the press, and certainly that has caused extraordinary offence to many people in the legal profession. The scale of that disappointment is quite unfamiliar to me in the 14 and a half years I've been in this parliament, the 30-odd years I've been involved in politics. And I think for the government to reflect on what they have wrought through that, the breach of faith, I think, is really very distressing for those of us who have great value on our institutions. This is a great deal more than just the use of whether the word king should be included in the use of expressing senior members of the legal profession's names or not. We used to use the word king today in this parliament in reflecting on celebrating those who had been given awards under the King's Birthdays Honours. And those people in the community do not seek the word king as an anachronism just because their honours had been given on a king's birthday. In our legislation, with the Public Holidays Act, we use the word king. We have, in fact, all sworn an oath to our monarch and their heirs and successors, as well as the people of South Australia. The very basis on which the two clauses in this bill in question is founded is utterly without standing. And it baffles me as to why the government has seen fit to bring this legislation. Why didn't they just vote against it a few years ago when they had the opportunity then, if they had the courage of any sort of convictions at the time? Their view was bringing back the option for QCs as they were then was not a first order issue of priority for the people of South Australia. But they supported the bill and then for years said nothing about it. They told the people of South Australia nothing about this issue before the election. And then we have this bill. This bill, which deals with, for 49 clauses, issues such as masters, and I was learning a lot about masters prior to the Leader of the House deciding to use the guillotine. Very disappointed that has happened. The use of the guillotine, and it is, I think, relevant in the third reading of the debate, reflecting on the entirety of the debate that's happened.
Reflect on a vote of the House.
Go ahead.
Go ahead.
I'm going to the motivation, sir. The use of the guillotine has happened, I can't remember the exact number, it'll be in the order of a dozen times, maybe 15 in the history of South Australia. I did it myself on a number of those occasions, and there were purposes that led to that occasion. We had, I think, and reflecting on a vote of a previous House, I believe is orderly, we had hours of discussions of short and long titles. At one point, I think the member for Ghana and the member for West Torrens brought out a thesaurus and looked through. I mean, the government members are remembering this with a certain amount of joy and glee. We listened for hours as people were reflecting on alternative potential titles for bills, utterly irrelevant to the conversation. The member for Hyson's comments on the first 2 or 3 clauses of this bill did not merit that approach. The government, having said that they were wanting to sit past midnight, we were resigned to the fact that they wanted to push this bill through. And fine. We did our votes on the second reading. We've made our position very clear on that. We'd made our points. We wished to ensure that the detail was scrutinised at every point and that the record would truly show our concerns, our interest, and that the concerns that have been brought to our attention by senior members of the legal profession and other people around South Australia were given every airing. But the government saw fit to move the guillotine, and I make no reflection on the decision of the House to do so.
Please refrain from reflecting on a vote of the House. You may make remarks about the bill, which you were doing before, so please go back to them.
I make no reflection on the vote of the House, and I won't come close to the issue again. Probably. On the bill, 49 clauses, whether necessary or not, are uncontroversial. 2 clauses in question. I think for many people it is baffling to the reasons why the government would move this way, having not previously expressed any interest in doing so. questions need to be asked there. Questions need to be asked about the basis on which they say that the legal profession was in support of it, because frankly that's not what I've been hearing. Questions need to be asked about which members of the legal profession or what status that support has come from, because it strikes me as a very narrow level of support. 70% of Law Society members surveyed not that long ago were very much in support of the previous arrangements, or at least support of moving to the previous arrangements. It may well be a different number now. Of those who have been given the opportunity to either take the QC or the KC title or not, a majority, as I understand, a significant majority, are using the KC title. The basis upon which that seniority is understood by those who are making themselves use of the legal profession and the several dozen, I think 5 or 6 dozen senior counsel in South Australia. Many of them are people for whom KC or QC is a readily known term. Many of them are people for whom the letters SC could mean any number of things. I declare an interest. My wife is a special counsel at a law firm. She is not an SC as will be understood here, but as the applicant, as the senior counsel, the King counsel, whom the member for Heisen was quoting before, identified, the explanation required at the beginning of a conference or a hearing in a jurisdiction that is not South Australia, it's a clipping of the wings of some of the people whose work we should be celebrating and applauding. I come back to this question. Nobody's asked for this. Well, that's incorrect. At least one person's asked for this. The government's yet to name another, as far as I can tell. And that's not the basis to have the law. And it's not the basis, having had the appropriation bill debated at great length over the last couple of days, having decided to start this bill after the dinner break tonight, in effect, to sit past midnight, sure, that might be a reason, but you know, this is the priority. Above, and I'll take a leaf out of the member for West Torrens' book from many debates before, 25 bills that I'm not going to name because we don't have time, but all of those bills that the government previously thought were important. The budget measures bill I will name, that strikes me as something that the government would have thought was important. Late payment of government's debts will be delayed so that the government can talk about their capacity to end what they describe as anachronistic use of King's Counsel. I guess they're proud of themselves. The bill will pass, and the opposition is disappointed in the way the government has undertaken this. I think the people of South Australia would be pretty disappointed in the same.